Hi, I'm Christie Ayotte with the law firm of Ayotte and Associates. Today I'm going to talk a little bit about temporary hearings. These are sometimes called Rule Nisi. They mean the same thing. So if your attorney or the court mentions a Rule Nisi, that's basically what it is. The purpose of a Rule Nisi is for the court to decide if certain temporary issues need to be decided. For instance, in a divorce case, the court might need to decide who's going to stay in the house. Other decisions that frequently come up at Rule Nisi include how are other bills related to the house going to be paid? Who will spend time with the children and during what period of time? How will the exchange of the children happen? Will there be temporary child support, and if so, how much? Will there be temporary alimony, and if so, how much? It's not required that you have a Rule Nisi, but if the court has already scheduled one for you, then you don't really have much of a choice about it. So from here, let's talk about how the procedure works, what evidence to use, and how to prepare. First, let's talk about procedure. Don't think that because this is a temporary hearing that you should treat it as anything less than a full hearing. Frequently, the decisions that are made during a temporary hearing extend into the future. They set a precedent that makes it difficult to unravel. So, for instance, if you know that you want 50% of the time with your children, you absolutely know that, you should not voluntarily agree to take every other weekend, because that's a lot less. And that communicates to the court that you are not interested in 50%. This is also why, by the way, when people ask for custody in their complaint or in their answer, they frequently ask for full custody, full physical custody, instead of joint part-time. So the temporary hearings are important. Here's how the process works. First, the plaintiff's counsel gets up and makes an opening statement. This is about 1 to 3 minutes. It's not testimony. It's just a chance to give the judge an overview of what the testimony is going to be. Then the defendant's counsel gets up and makes their opening statement. Then the plaintiff's counsel calls their witnesses and they testify, and if you're one of the parties, then you'll be one of those witnesses. And that looks pretty much the way that you see on television, except shorter. On TV, trials seem to last forever. A temporary hearing typically does not last more than an hour and a half for the whole thing from start to finish. And frequently they are much shorter. So then at the end of it, the judge will consider all of the evidence and usually makes a decision on the spot and orders one of the attorneys to write down an order and prepare it for the judge's signature. Sometimes judges decide to think about it and issue a ruling later, and that's just what happens sometimes. So what kind of evidence do you put on? First of all, you don't bring your kids. Uniform Superior Court Rule 24.5 sets out the kinds of evidence that you can use. Dragging your kids into the middle of a dispute, even if it is about them, makes you look bad, and it's not good for them. It's psychologically scarring to pit children against each other. So your children will not be witnesses. You will have your own testimony, and that's evidence, because you'll be sworn in under oath, and you will offer your account of what has happened or what you want to happen. You can also bring another person with you. At temporary hearings, each person is allowed to bring one additional witness. So think carefully about who you want that to be. If you have additional people that you want to bring as witnesses or additional facts that you want before the court, then you can introduce additional evidence through deposition transcripts or through affidavits. Now, an affidavit, you don't need any special legal training to fill out an affidavit. All it is a sworn statement signed before a notary where the person says what they saw, heard, touched, felt, observed, You want to be careful that the person you're getting an affidavit from isn't simply repeating things that you told them, but is instead listing things that they have observed personally. Here's the deal about affidavits. You have to provide copies of those to opposing counsel at least 24 hours before the hearing. If you do not, opposing counsel will object to your use of the affidavits, and the judge should sustain the objection, meaning you will not be able to use them. So, for example, if one of the things that's important to you at this temporary hearing is that your ex has this shady sister who is a drug dealer and constantly has people in and out of the house, and you want part of the temporary order to be that the children are not to be around the shady sister, then you need to provide a copy of that affidavit from the people who can testify about her drug dealing. You want that to be provided to opposing counsel in advance, because otherwise you can't use it. The other important thing to note about preparing your evidence is that you need 4 copies of everything. Copy for you, copy for opposing counsel, copy for the judge, copy for the court reporter. The court reporter's copy is the one that you're going to hand to the witness when you talk to them. You're not allowed to ask people questions about things that they're not looking at or they haven't seen. Well, you can, but they have a right to object if you do that. So make sure that you are over-prepared. If you don't have a thick folder of items, you're not prepared enough. Make sure that you practice what you're saying to ensure that you are talking about the things that are important and leaving out some of the background and the miscellaneous things that are likely to make a judge lose interest. That's it for today about temporary hearings. Good luck.